They really are things that people take for granted and just look at as really a nuisance until something happens and they need to either get around them, or if you are the party who is relying on it, you need to try to rely on it. Hello and welcome to the next episode of Beneath the Law. My name's Gavin here with my good friend, partner in law, and sometimes in crime. Well, figuratively speaking, of course, Stephen Teal, the one and only.
How are you doing, Gavin?
I'm doing pretty good. We're going to do an episode today on something that I know nobody ever reads. Nobody reads them. When's the last time anybody read the back of their tow ticket at a ski hill, or read the back of a Blue Jays ticket, if there even is such a thing anymore, or even better yet, when's the last time anybody actually read a user agreement on an online service before clicking I accept all of the terms? Put your hand up if you're that person. Because I've never met them. I think that they're. I don't think there is such a person. I don't think anybody reads that stuff. That's just my take of it. But who does read it? Judges read it. And when do judges read it? Judges read it when things go very, very badly. So these waiver of liability type language that we see in all of these things. They really are things that people take for granted and just look at as really a nuisance until something happens and they need to either get around them, or if you are the party who is relying on it, you need to try to rely on it. And one case that there are obviously thousands of these cases, but a recent case out of British Columbia sort of highlighted what is incredibly tedious process of actually reading the fine print on all sorts of agreements, and what do they really mean, and do they have any impact at all? Are they just a waste of verbiage?
It depends, I guess, Gavin, in terms of context, but let's get into a little bit of the background of the case here. It's a case in British Columbia, as you said, Court of Appeal upholding a lower court decision in a case where a participant in a rock climbing adventure was injured and then sued the mountaineering guide company that he had hired to take him on this trip. And to participate in the rock climb. The mountaineering company said, well, we don't owe you any money because you signed an online waiver of liability form. The court took a look at the form, and what they found was that because the person who was injured entered a specific date on the form, which the form had requested that be completed, the waiver of liability did not apply because the climber was injured on a subsequent rock climb and had never signed a separate waiver in relation to that particular climb. So that, in a nutshell, is the background of that case, and why waiver of liability clauses or limitation of liability clauses is the subject of our podcast.
Yeah, these clauses are there. I mean, a lot of people will say they are boilerplate. I mean, they are what are referred to in law often as contracts of adhesion. And a contract they are the terms of the engagement of the participation in a given event or activity, or use, for example, of a site. If you're using, I don't know, Amazon, or if you're using Facebook or anything, you're agreeing. There's a contract that sets out what the terms of that use are. And most people, frankly, would have no idea what the terms of the use are. But the contracts are written, obviously, by the party who is seeking the protection, and are usually very much in their favor. So you have what I'll call the boilerplate or a contract of adhesion. This is it. If you want to ski on this hill, you agree to this, or not. There's no negotiation involved, and these are strict terms that are drafted by the provider of the service for their protection, and they are designed to exclude and exculpate the provider of the service from liability. And people will say, well, that's not right, that whatever, but there are good reasons for that. And one of them, I would think, is if you're involved in an inherently dangerous activity. Skiing is the one that obviously comes in. Skiing's dangerous. People get hurt skiing all the time, every day. I would think on a major ski hill, somebody gets hurt, and sometimes very, very seriously. They get killed, or they're rendered quadriplegic, or breaking legs, or whatever. And you can imagine that if the ski hill was on the hook for every one of those injuries, they'd be broke pretty quick, and the insurance that they would have to pay would be astronomical. I mean, the premium that an insurer would charge someone like that, if they were getting sued successfully all the time, would be enormous. In other words, you'd have to take out a mortgage to go skiing, because the cost of skiing would go through the roof. So these waiver of liability clauses, to some extent, I suppose, are a necessary evil in terms of the economies of providing any of these services, because if you didn't have them, it would be economically impossible to provide those services.
Yeah, I look at it from the opposite perspective, right? You say it's a necessary evil. It is a necessary benefit, in my view, to promoting economic activity, to promoting recreational activity. So, just to back up a little bit, waiver of liability clauses exist particularly in commercial kinds of contracts. Transportation contracts have limitations of liabilities for lost goods and damages. And, even air travel has limits on liabilities for lost items. So in the recreation industry, waiver of liability clauses are quite common, whether it's skiing, participating in hockey, any kind of activity where a individual is buying a service, doing a ride at an amusement park will have certain limitations on liability, because these activities on the recreation side, can lead to, as you say, serious injury, even minor injury, and in some cases, death. There are fatal injuries, and those are the cases that you see frequently litigated, that do go to the courts, and there are, a small amount of very strong decisions that speak to the public policy purpose behind courts being willing to uphold these kinds of clauses because of the economic interests that they protect, and other cases that speak to why the waiver of liability should not apply. And quite frankly, there's a balance that the court needs to consider in terms of either protecting the economic interests of recreational business operators versus the interests of victims who have been injured when participating in some of the activities.
Yeah, look, I mean, I think it's always, visually speaking, we all have seen the statue of justice with the blindfold and the scale in front of it. And the balance is important. Balance, courts, generally speaking, are always balancing competing interests. And I think the competing interests here are significant. I mean, in any of these activities, I mean, as you were speaking, I was thinking, to myself of the old Latin phrase, "volenti non fit injuria," which means that a volunteer can't be injured. What does that? What does that mean? It means that if I go out, if I'm going backcountry skiing, I mean, I know it's a risky activity. I mean, if the suggestion that somebody's going backcountry skiing and thinks it's like I don't know, sitting in an armchair is ridiculous. I mean, there is are some activities are inherently more dangerous than other activities, and the that Latin maxim of volunteer can't be injured is simply saying that look, if I go participating in backcountry skiing, I know that there's a possibility that I'm going to be injured, and I voluntarily assume that risk in undertaking that activity. So, for example, if I were, I don't know, really adventurous and I didn't go to a commercial ski resort and I climbed up a mountain with my skis on my back and then I skied down the mountain and fell down, I'd have nobody to blame but myself. Because I knew the activity, or I should have known that the activity I was undertaking had risk, and I voluntarily took that risk. So, what these clauses in these agreements, I think, seek to do is to apportion the risk in an activity clearly and unequivocally, and generally speaking, flatly on the consumer of the service. In this case, the rock climber, who didn't come out of it very well, unfortunately, sadly. But I think what the one going back to the other point, that it's all balanced in terms of that. I mean, I don't think that this individual forget about the fact that there was a waiver of liability clause, which we may or may not have read. But nobody's going rock climbing and thinking that it's completely free of risk. Rock climbing is risky. There's a thing called gravity that would probably cause you some trouble. And if it goes the wrong way, yeah, rocks are hard. So if the combination of rocks and gravity is generally dangerous, and there is risk involved in it, and that was what happened here.
Right, but the mountaineering company was held liable for his injuries because they've held themselves out as a service that they're going to provide an experience that a user, I guess, can rely upon, that will be, quote, safe with respect to the assumption of the risk that the guide is not going to take the climber on a cliff that will be dangerous to that climber, or on a path that will not be dangerous, that there is a somewhat of a reliance on the user, that the guide knows the person's skill and level of skill after seeing them climb, to not take them on a dangerous kind of path. So for the business operator, yes, they're providing risky activities, and therefore they need to be able to protect themselves, because remember, they're the occupiers in certain circumstances where they actually own the lands. So there's legislation that talks about occupier liability for dangerous things that are on your property. In this case, with the mountain climb, it's more of the guide taking their client on a climb that perhaps was too dangerous. So that's why you have the waiver of liability form signed, right? It just goes beyond that assumption of risk.
Yeah, let's go back to our scales of justice and balancing again. And one of a very wise senior lawyer once said to me a long time ago that you should think like a judge, and when you're looking at a case and faced with the situation, let's put yourself in the shoes of, as a listener, thinking about this. You're put in the shoes. You've got to very seriously. I think this individual were they killed or very seriously injured?
The case actually didn't. The appeal case didn't speak about the extent of the injury. He wasn't killed, but he was 63 years old at the time of the climb, so he was an older gentleman on the climb. And the evidence was that there was a bit of a not a concern, but certainly the guide understood that he wanted to check the skill of the climber, wanted to make sure that the climber's equipment was good. They had discussions beforehand before the waiver was signed, but the real turn on the facts was that rather than having entered into a series of climbs, uh, there was only one climb that they ever agreed to do together, and that was the first climb for which the waiver was signed. So there was then a second climb at a different location, and a third climb at again, another different location in the British Columbia interior. And it was on that climb that actually they were both injured. So both the climber and the guide were injured on the climb, but there was no waiver of liability signed.
Well, yeah, okay. So this is my point, though, that these waiver of liability clauses are drafted by the provider of the service. They
The
are
business operator,
dictated
right?
to that. The terms are dictated. You don't negotiate the back of your ski tag. So it's take it or leave it. And they are invariably written for the benefit of one party to the detriment of the other party. And as a result of that, there's lots of rules of contractual interpretation that come to that. But basically, the courts will, I think, very strictly construe that type of an agreement against the party who drafted it. So if there's any picadillo or issue or inconsistency or incongruity, it's going to be read against the person who drafted it because they had the opportunity to draft that however they want. And in this particular case, the point that the court found was the defect, if you will, in the strict enforceability of the clause was that it had a specific section for the date of the climb.
Correct.
He had signed a prior one with respect to the date of a particular climb, and then he had gone on further climbs afterwards, and they didn't fill out specific dates of it. And the court said, no, it's a strict clause. It's strictly construed against you, mountain company, and you didn't put the date in, and there was a date on the other one. Therefore, you have nothing for this particular climb. You have no exclusion of liability. You're on your own. Straight negligence principles would apply. Did you comply with the standard of care of a reasonable and competent tour operator in these circumstances? And in this case, the finding was no, you didn't, because there were signs or you were negligent in the manner in which you provided the service. So these types of clauses are always going to be read hard, frankly, against the party who drafted them. And that doesn't really bother me because that is fair in the sense that if you've got the opportunity to dictate the terms of the contract, you better get it right. And if you make a mistake, that mistake is going to be read against you.
Well, and look, it's the case law has developed certain principles with respect to these kinds of contracts because at the end of the day, Gavin, these are consumer contracts of note, right? It's not corporations that are entering to these contracts. It's the average consumer that's entering into the contract. So the law has developed in order to protect the businesses that, the waiver of liability provision must be clear. The giving up of the right to bring a lawsuit for damages must be clearly drawn to the attention of the user. With respect to the contracts where participants enter into an actual agreement, it has to have bold font that you're giving up your right to sue. The language has to be clear and that you understand concisely what is being conveyed or what you're waiving in terms of your liability. So there has to be clear, concise language in the drafting of the waiver so that everybody can understand it, that the general person can understand it. With respect to the ski ticket, again, the ski ticket on the back should still have bold font, all caps, in terms of the waiver of liability. And if you go to a ski hill, you've got signage. Signage is all over the place that you're accepting the risk. So those are the things that courts have basically required recreational operators to have to ensure that that waiver of liability, because as you say, most people don't read them, that it's drawn to your attention.
Well, I mean, I think we come back to the, I always look at this in a sort of a big picture way. These are the reasons why, in this particular case, the court articulated a a decision that they were not going to give the tour operator the benefit of the exclusion of liability uh, language in the prior agreement. But I still think it comes back to this overarching sort of balancing of interests. We have, on the one hand, I think of a valid interest in enterprises that are conducting business in what is an inherently dangerous field, and that, frankly, is what people are partly why they do it. I mean, people like the thrill. I mean, your amusement park analogy is a good one. No one wants to go on a boring roller coaster. Everybody wants to go on the exciting, super fast roller coaster because it's fun. And so they provide a product that people like. The people want that risk. They want the thrill of something that is got some element of danger to it. And that's part of our, it's part of, people have the right to do that. And there's nothing wrong with that. And if you made the enterprise so dangerous from the perspective of liability, nobody would do it. There would only be boring roller coasters, and the public would not get a product that it wanted. On the other hand, as a judge sitting there, here you've got, in this particular instance, I'm assuming, let's say this individual was very seriously injured. You've got a 63-year-old, almost retirement age individual who is maybe sitting there in a wheelchair, maybe they're paralyzed, I don't know, in any event. And as the judge, gee, that's going to cost a lot of money to look after this person for the rest of their natural life. And let's assume that they were paralyzed and they were going to have 24-hour care. I mean, as a judge, in the back of your mind, it's got to be running, and there will be evidence before you as to what that future care cost would be. And you're sitting there going, this is a really bad situation. What do I do here to try to help this person in this situation where really at the back of the judge's mind, and I don't know if this is true or not, but they're probably thinking, look, there's an insurance company behind the mountain climbing company, and they've got lots of money, and their money will look after this person. So if I can find a way around this clause contractually, I get to help this person out, and I get to put them, put them in a position where they can live, not optimally, obviously, but they will be looked after in the sense that they will not be destitute, and frankly, a burden probably on the public system, because if they have no other means, they would be falling back on the usual social services provided by the government. So those are all got to be playing in the mind of any judge. And I think a judge looking at the person in front of them would lean hard I'd really like to find a remedy for this person. And I think that people need to understand that judges are people too, and that they look at it that way. And frankly, you wouldn't have it any other way. You want them to want to help people.
Well, look, I think, Gavin, that's true to a certain extent. There's no doubt, in my view, that certainly that may be going through the minds of a judge, but I think that's important for business operators to note, that courts will be willing, in those kinds of extreme cases where there is a fatality or a serious injury, to look for ways to get around the waiver of liability. So businesses need to be, very strict in terms of the way that they operate, carefully administer that there are waivers of liability every time a participant signs up to take on a dangerous activity. There was an interesting case cited by the Court of Appeal about a hunter who was shot and killed on a hunting trip, and had signed waivers of liability every time they went on hunting trips every year. But for this particular year, the outdoor company did not have him sign a waiver of liability. And so the previous waiver of liability that was signed all the time didn't apply. So from an administrative perspective, businesses really need to be vigilant in terms of getting these waiver of liabilities. Now, one thing that we haven't touched upon, and that this case doesn't touch upon, but just from a waiver of liability perspective and the law, no court in Canada has ever made a ruling with respect to waiver of liabilities impacting minors. And parents sign off all the time for their kids to participate in sports. And those waiver of liabilities in general are not enforceable because children can't enter into contracts.
Well, but children can enter into contracts if they have a guardian. Just like, if children, we're really getting into it now.
But look,
children enter into contracts all the time. They have guardians and or trustees or what have you that enter into the contract on their behalf. They can't enter into a contract, on their own because the law deems that children are incapable of providing informed consent to whatever they're agreeing to. Because they're not capable. They're not at the age of consent. That really means that you've got to be. There's a point in time where you're capable of understanding something and not. Now, that's an interesting point. As you were saying that, I was thinking about you send your kid on a trip with the school. They have to get a consent form to go on the trip. Which generally speaking says that you assume all liability, blah, 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 all the rest of it. Interesting question. So your point is that the child would be able to sue regardless of the waiver of liability clause because it's not enforceable against the child, even if it was signed by a duly authorized guardian?
That's certainly the general view right now of the law. Everybody, every lawyer that you speak to would say that waiver of liability is inapplicable because remember, it's the child who's injured. Are they, have they made a real conscious choice to give up their right?
Right.
I think this gets into your balance of who is the court going to protect?
Right. Here we are again. You put yourself in the shoes of the judge hearing the case. You're sitting there with a very seriously injured child in front of you. And you want to do something to make that child's life better.
Yeah.
If you had a child, for example, who was paralyzed and would be literally needing care for the rest of their life, or had a serious brain injury.
Exactly.
And needed care for the rest of their life. Are you going to say, oh, too bad, and looking at a parent who can't afford it?
Right.
And say, too bad, your parents signed the form. We're going to let this insurer behind the scenes here off the hook. The insurer who is in the business, frankly, of taking in money and assessing risk, and hopefully, if they're a successful insurer, taking in more money for the purposes of basically selling risk and putting it in their pocket. And they're basically trying to run a hedge game, if you will, on risk, in the sense that they're taking in more money than they're paying out on various types of risk, be it life insurance, accident insurance, liability insurance, whatever. That's what insurance is. Insurance is about basically handicapping and hedging risk and taking in more than you spend. So a judge looking at that going, what do I like better? The actuarial insurer who is just crunching numbers on money in, money out, or this poor, destitute, disabled child who has been injured?
Yeah, it would certainly be an interesting test case, but I think it would be a risky test case to take on. Just of note, just to close this off, Gavin, in terms of other things from a business perspective, businesses aren't protected if they provide faulty equipment, either by a waiver of liability. So it's, the business does, if they're providing equipment, need to check to make sure that their equipment is sound. Just because a waiver of liability has been signed will not protect you from a business. And there's actually a case in terms of from what I recollect, a horseback riding case where somebody's stirrup broke, and so the saddle fell off the horse, and they were injured when they tumbled down to the ground off the horse, and the equipment was found to be faulty, and so the waiver of liability didn't apply because it doesn't protect against faulty equipment. You're entitled as a user to make sure that if equipment's provided, it's sound and of good quality.
And that's great public policy. I mean, as we've discussed this, the balancing of interests, balancing of issues, balancing of the rights of the various parties. It's critically important that, look, the public policy of the court should be designed to drive best practices and avoid injuries. I mean, the purpose of these, if there was sort of carte blanche, you sign a waiver, too bad for you, out you go, you're not getting a dime, then there would be no impetus on businesses to be careful, to provide good equipment, to avoid the injury in the first place. And it is important, I think. This balancing is really critically important, and it has to go on a case-by-case basis, which it does. But when you really step back and think about it, there's all sorts of, very bona fide competing interests, all of which have value, that have to be considered. And you want businesses to be responsible. You want them to be worried about people getting hurt. You don't want them to say, well, I don't care. I got a waiver of liability. I don't care. Go fall off the mountain. What do we care? You want them to worry about that because you don't want people to get hurt. You want to do whatever you can to prevent it. And unfortunately, with courts, courts are not dealing with all of the people who didn't get hurt. They're dealing with the one or two people who did. And those are always the tragic cases when something went wrong. Those are the cases that end up in courts. And those are the cases that end up as law cases. And those are the cases which drive the public policy element of all legal decisions and the precedent value of them. And that's why, I guess, Stephen, if no one is above the law, then everyone is beneath it. And we'd like to thank you for coming and listening to this latest episode of Beneath the Law. Please rate us on your favorite service. Please subscribe. So you never know if we might be talking next week about a topic that is near and dear to you and you'd be really interested in hearing about it. And if you're not subscribing, you may not know about it. So subscribe and rate us if you can. Big shout out to our producer, Doug Downs. Thanks, Doug, for another great episode. And we hope to hear from you, and we hope that you hear from us again on the next episode of Beneath the Law. Thank you.